Good afternoon, and thank you so much for tuning in to Chapman Law Group to another episode of our video log. Today we're going to talk about the administrative law process in the state of Florida. Although many states are similar, so a lot of things we're going to talk about can translate into other states. And with us today we have Lauren Lycum, one of our attorneys in the administrative law section and a former prosecutor for the Department of Health in the state of Florida. Good afternoon, Laura.
Good afternoon, Ron.
Could you tell the audience a little bit about yourself and why were we so lucky to get you?
I graduated from law school from Florida State University in 2008. I immediately started working for the government. A lot of that time, the majority of that time, I spent 6 years with the Department of Health, 4 of which were as a prosecutor for prosecution services, basically all medical licenses that are governed by the Department of Health. So the bulk of my background does come from prosecution.
So
I've been working here.
So you know the inside track then, right?
I do.
Good. Well, we're here today to talk a little bit about administrative law. What is administrative law?
Administrative law is really a hybrid of administrative practice and administrative rules, and it's kind of married with civil law. So depending on what you're doing, in some cases you may follow what the administrative rules say, and sometimes you may follow what the civil law rule says.
Now, people in the state of Florida, well, it doesn't matter which state they're in, professionals are typically licensed by some board in the state. Is that correct?
That's correct.
And when we're talking particularly about medical boards, how are those functioned? Do they operate under the Department of Health, or does the Department of Health serve the boards? What's that relationship?
The boards basically exist, they're appointed. The Department of Health investigates all complaints against licenses and brings that to the board. But the board has the final decision. So for example, if someone is going to enter into a settlement, they can enter it with the prosecutor for the Department of Health, but the board has got to be the one that approves it.
And then there's this entity that we see in Florida called quality assurance. What are they and what do they do?
Medical quality assurance is basically a division within the Florida Department of Health that handles all complaints against medical healthcare professionals. So in medical quality assurance, you have the investigative services unit, you have the consumer services unit, you have the prosecution services unit, and all these various units all work together to investigate complaints and then prosecute them. But it's all under the same umbrella.
So let's kind of go back to the beginning. What are some things that a healthcare professional can be complained about? What are some situations that come up before the board?
Repeatedly, I see a lot of diversion or stealing drugs and narcotics from the workplace. A lot of failed drug screens. If you fail a drug screen, even if it's pre-employment and you never end up working there, they're still required to report that to the Department of Health, so that's very common. Anytime there's an adverse incident, so if a patient is harmed or patient dies, usually a report goes to the Agency for Healthcare Administration, and the Agency of Healthcare Administration, that's AHCA, reports to the Department of Health, and then all of the individuals involved can end up having a complaint depending on what role they played in the incident. I mean, those are the typical things.
So when it comes to complaints, a consumer can call up and complain about a healthcare provider, correct?
That's correct.
An employer can do that. If an employer terminates you for, drug diversion, or because they felt you were incompetent or something, they can file a document with the department, a complaint with the department.
Yes.
And then I guess fellow providers, if they see something wrong that they think's a violation, if I'm not mistaken, they're actually required to notify the board, aren't they?
They are in most circumstances, yes.
Okay, so let's go back to the beginning. So somebody makes a complaint somehow, any one of those 3 ways, and then what typically happens? What's the first thing the provider's going to see?
So you're going to get a letter of investigation from the Department of Health that should include a summary of what's being alleged, along with any additional documentation, and this is your first chance to respond to the complaint against you.
Now, let's take primarily nurses, Board of Nursing, healthcare providers, or physicians, the Board of Medicine, Board of Osteopathic Medicine. If you're a physician, you usually get 45 days to respond, and if you're a nurse or a massage therapist, a PT, OT, you get 30 days to respond.
No, this is, so they're all 20 days to respond, except some are 45 days, and that depends, to my understanding, what unit it's coming from, whether if it's consumer services or if it's from investigative services. It doesn't seem to be all that consistent, but the majority, I would say about 75%, you have 20 days to respond is the general rule.
So I'm a healthcare provider and I get this letter. What should I do?
The first thing you should do is contact an attorney. This is the best time to have your case evaluated by an attorney, because the department is going to be asking you for a response. They might be asking you to even sit down for a recorded interview, and you don't want to do that until you've spoken to an attorney to make sure that you don't make any admissions that you don't want to, that you don't jeopardize your case.
Now, I've heard this many times from clients that have come in and seen me. They've already picked up the phone and they called. They thought they could resolve it with the conversation with the board. Is that at all advisable for the healthcare provider to call the board and think they can just resolve it with the conversation?
This is generally a really bad idea. The investigator is going to record what you say, and then when they're done with their investigation, they send the whole case up to prosecution services, where an attorney will look at it and see if they have enough evidence. So if you tested positive on a drug screen and you get on the phone and you tell the investigator, oh yeah, I took my boyfriend's extra Percocet laying around, then your case is over. Then they can just prosecute you from there.
Now, when we're talking about getting this letter for investigation, you said it could be an adverse outcome. It could be related to, a violation of the law, I guess. You were arrested or charged with a felony or arrested with a felony. But many of them are just violations of board rules relating to that particular field, correct?
This is true. Mm-hmm.
And what kinds of things are in those rules? What kinds of things would the board want to investigate, aside from the obvious ones, an adverse action, a felony, things like that?
The biggest board rule is going to be diversion, and they're gonna hook that under the rule for misappropriation of drugs or supplies. There's also abuse of patients that they're going to look into, take very seriously. Abuse, theft, impairment, those are the big ones.
Okay. So you get this letter of investigation, you talk to a lawyer, to an attorney, presumably a healthcare attorney, somebody that has experience. What is that person going to want to know? What kinds of information could me as a healthcare provider bring that would help the attorney better investigate this?
It's always important for the attorney to know the circumstances and what's really going on in your case, and that's going to vary. But one of the things we generally ask when we write our responses, we like to put in a lot of background, a lot of evidence about the great stuff that our providers do. So we're going to ask for your resume, we're going to ask for letters of recommendation, any awards that you've received, things like that, so we can present a full picture to the probable cause panel.
And if the allegations are more factual, like they say, the allegation is that you hit a patient, let's say, do we on occasion, when occasion warrants, do investigations, go out and talk to witnesses, look at video, do a complete investigation to see if there's support for the allegation?
Do we?
Yes, we do that.
Yes, no, we do. Yeah. We do, and it depends on what it is, of course, and the overall strategy for the case. But in general, yes, we do go contact witnesses and find out if we can get enough evidence to support our legal theory.
Now, what's the end goal with a letter of investigation? Ultimately, what do we want to try and accomplish for the healthcare provider?
This case is ultimately going to be heard by the probable cause panel for the board that the person is governed by. And we want this case dismissed at the panel. So our first goal with the letter of investigation, this is the first crack at the apple to give the panel enough information to dismiss the case. After that, there is, if the department's going to go forward, we get the investigative file, which is all the department's evidence, and we review it, and we get a second shot to respond to the investigative file. So by the time it gets to the panel, panel meetings are not public meetings, so we cannot attend them, but they should have 2 responses from us about your case.
In those responses, we're trying to argue that there was no basis to bring this action, therefore it should be dismissed.
Yes.
Okay. Now, what else can the probable cause panel do? They could also decide to file a complaint.
They can.
And they could give you a letter of reprimand, or not a letter of reprimand, a letter of concern.
They can do a letter of guidance, which is great because it is a dismissal. It closes the case, and the letter is non-disciplinary. So what it is it's a letter that says the panel was concerned because on this date you violated whatever you violated, and then they tell you not to do it again, and the case is closed. But you can only get one of those per violation in your career. So if you already got a letter of guidance because of a failed drug test and you fail another drug test, you can't get another letter of guidance.
Okay, so we had this letter of investigation now. Let's assume the board dismisses it and says there's no probable cause to move forward. Do I have to tell my other employers that I was involved in an investigation?
No, you do not. It is confidential. If they were to call the department and ask about it, the department wouldn't be able to confirm or deny the existence of that case. But that being said, you always want to watch out on the way questions are phrased. Sometimes employers will ask you, have you ever been, has your license ever been disciplined? Obviously the answer would be no. But if they ask you specifically, have you ever been investigated? You know, you don't want to be dishonest on that, even though your case is confidential.
Because if you're dishonest, that can be a reason to revoke your license by the board, correct?
It could be, especially if you're talking about on an application to the board for anything, or say you're trying to upgrade to a compact license and you don't mention another investigation, that could be an issue.
My experience has been that not being truthful with the board, lying to the board, being deceitful with the board, they really take that seriously, and they punish people very harshly for doing that. Has that been your experience?
Yes, it's treated, I think it's treated harsher than a lot of other offenses. You'd be surprised.
So let's assume the board finds there's probable cause. What happens now?
If they find probable cause, then they will issue an administrative complaint against your license, which is a public discipline. It will stay up on the MQA website, that's Medical Quality Assurance. It will stay up on the website, and even if you resolve it. And then after that, you've got 3 different ways to resolve it. You can choose to settle your case, which is where you neither admit nor deny the facts, but you choose to take a settlement. That's what a lot of people end up doing. There's a chance for an informal hearing before the board. In that case, you are admitting to the facts in the administrative complaint, but you appear before the board to present mitigating factors. And from there, the board decides what discipline they're going to issue. The last option is for a formal hearing before an administrative law judge. This is the only one where you can contest the facts in the administrative complaint, but it is like a full trial.
So when the complaint says, for example, that let's say you're a CRNA and during your break you were out in the commons area drinking a beer and they file a complaint against you and you weren't there. That's factual stuff that you should try that case. You should appear before an administrative law judge and try that because the facts are with you, right?
Right.
Should you be afraid of that? You know, a lot of people, they say, well, I don't really want to go. It's all rigged. Is that any truth to any of that?
No, I definitely not. The only thing you want to be, and this is why you want to talk with an attorney to have your case evaluated, but the only thing I would bear in mind is that the department does not have to prove things like in criminal court beyond a reasonable doubt. In some cases, they don't have to prove the offense at all. For example, if you entered a plea to say battery, They do not have to go to court and have a whole battery case and try to find out whether or not you did that. They just have to enter the conviction, the piece of paper, and they win the case. So it's really important just to have your case evaluated by an attorney to see what you got.
And as a healthcare attorney, part of our regulatory division, not only that evaluation, but taking things to a hearing, those are things that you and the team that you work with do on a regular basis, correct?
That's correct.
Okay. Do you like doing it?
I do.
Why?
I like it when I can get a good result.
You don't like it when you get a bad result?
Yeah, pretty much. I don't like bad results.
Okay, okay. So now we go to the board. The board finds in our favor, or not the board, we go to administrative hearing, they find in our favor. What happens now?
So if you do a full administrative hearing, the person making the recommended order is an administrative law judge, but it's just a recommended order. It still has to be approved by the board. So after your trial, you have to go back before the board, and the board, you know, they can't change the findings of fact that the ALJ has found, but they can alter the penalty. So the board still has the final say over that. But ultimately, if the board approves the recommended order, it becomes a final order, and then your case is done.
And the board has, if I understand correctly, they have great latitude to do a lot of things. They can dismiss, they can revoke your license, they can give you a reprimand, they can fine you as much as, I think, $20,000 or $10,000, depending upon your profession. They can make you go back to school. There's a whole host of remedies they can come up with.
It's true. They do have guidelines. They have disciplinary guidelines. They are supposed to stay within that. It sets forth what the penalties should be between for each violation of the law. But they can deviate from that with mitigating or aggravating evidence. They can deviate.
Let's talk about that for a second. So let's assume you did something wrong. Let's assume, I don't know, you know, you gave the wrong dose of medication, or you just admit to doing it. This mitigation, tell us a little bit about that, and why is it really important for the board to know who you are and how you got here, and why this thing will never happen again?
Because this is where you can convince the board to be lenient. And so one of the things, you know, you might want to do is say, if you've been accused of diverting drugs from your employers, you might want to say, well, look, I've gone to treatment. I also did drug court. I got my criminal case dismissed. I'm compliant with drug court and compliant with treatment. And I've done all these things to better myself. That might, you know, they're still going to refer you to an impaired practitioner program at the end of the day. But that might be enough to make them take it easy on other things, or, you know, avoid revocation if it was a substantial amount of drugs.
What's your experience about the board's intent? What do you think is the overriding theme or the overriding motivation for the board to do whatever they're going to do?
The board's primary concern is protecting the public. So, you know, a lot of times it's not personal, and it's not about the person themselves or what they've done. It's about this happened and what do we need to do to protect the public, and that's their dominant concern.
So regardless of what the allegation is, it's very beneficial for the provider to work with trained healthcare administrative law counsel to put together a solid package so the board knows who you are, and more importantly, are convinced that this won't happen again.
Correct.
Do you do that regularly with your clients?
I do that regularly. I just had a slew of board hearings. I had 6 I attended in December, and they were all, they were either settlements or informal hearings, all of them. Where, you know, even on the cases where we, you know, accept a settlement agreement, like I said, the board has the final approval on it. So sometimes if they see a settlement and they say, hey, this is too light, and then we provide the mitigation to explain why we've decided to go a softer route than what they're expecting. So even on hearings where we've entered a settlement, we still have to present evidence.
So if a case is divided into 2 segments, the first being the investigation and the second, let's say, being the adjudication or the complaint and discovery and all that. Excuse me, how long does the first process take? Are we talking 30 days, 90 days, a year? How long can it take?
This really varies greatly, and there's no consistency with it. The Department of Health is just backlogged. So I have cases, I truly have cases that are in the investigation stage for over a year. I'm still waiting to hear back from the department. On the other hand, if there's something going on where there's an emergency action, which would be something that could get you suspended or restricted from practice, those cases are expedited and they're supposed to be handled immediately. So the investigator sends them to the prosecution services unit. That attorney is supposed to get that case out the door within a couple of days. So the whole 20-day rule and the time to respond to the investigation doesn't apply to emergency actions. But in any case, like I said, some of them can go really quickly in that case, and others can linger.
And sometimes it's just a matter of the department's working on something, we've sent them something. I guess my concern is if there's a delay, does that mean there's something wrong going on? Should the provider be nervous and calling you up every day, or are there delays pretty common in this process?
Delays are completely common in this process. And sometimes it's actually good because that means that evidence is getting old, witnesses are forgetting, things like that. It might be to your advantage to have your case take a while. But usually it just means the department is behind.
And I assume the cost of this kind of investigation, trial services support, it varies depending upon what the allegations are and how serious they are, how in-depth the facts are, correct?
That's correct. I mean, some cases can be investigated easily, like a failed drug test. Other cases where we have diversion from a hospital where there's many patients involved who didn't get their medicine and there's just voluminous records are going to take longer.
Now let's talk about just a minute like diversion or a failed drug test. We have, without disclosing all of our strategies, we have some pretty patented strategies that we use that can put our client in a really good position. Do we?
We do, and it depends on the circumstances of each case. But normally, sometimes we'll refer them out to a different kind of expert that might be helpful. We might refer them to an evaluation. We might, if we can get our hands on the drug test, we would get that drug test reviewed by toxicologists to see if it could have been caused by something else, things like that.
Now, you're in the regulatory division of Chapman Law Group. There are also other folks in compliance and other things. And do you work with them? White collar, they do a lot of, the criminal investigations. Do you work with other departments when needed to bring in some deeper expertise into something?
I do. The most common time I do is really with criminal cases. So I do have some criminal cases that I take when they have a corresponding Department of Health case. And so the classic example, I think on all of them, they're diversion cases where the person was also charged with grand theft from their employer. So when we have a case like that, I also work with attorney Jonathan Meltz in the Miami office a lot. And then other things, if I have questions or I need to talk about compliance, we've got plenty of attorneys up in Michigan I can speak to.
And with respect to physicians, we also do a lot of medical necessity, failure to comply with the standard of care, in depth as to whether or not the physician complied with the standard of care. Do you participate in those as well?
I do, and for me personally, I think they're the most interesting cases. We usually always get an expert witness to review all of the patient's records and come up with an opinion to help us fight the case.
Great. Well, that's all the time we have today. We'll bring Lauren back at another days to talk about some very specific things and strategies that she can do and Chapman Law Group can do to really go after a complaint. The one thing that we do and Lauren does is we don't just sit back and let the department do what they want to do. We take the case, We marshal it through, we push it through, gather the evidence to support you. And above all, the department wants to protect the public, and we want to protect you. Lauren's a big part of that team, works out of the Sarasota office. So thank you so much. We'll have you back another day.
Thank you. Have a good one.
Have a good day, everybody.